Welcome to Stock Law Now. I'm your host, Scott Colasanti. For the second time in 10 years, Congress is talking about passing a law preventing insider trading by Congress. This raises the question, Congress still passes laws? This raises the question, why is insider trading so darn irresistible? And so, from a part of the garage where even resigned governors won't hide, it's We Heart Insider Trading, the year's first podcast from Stock Law Now. As always, Trusty Cherry shall warn when I go too far. And here we go. Here I am, rock you like a hurricane. Dateline, early 2022. It was another banner year for the SEC's insider trading caseload. In the past 12 months, the Securities and Exchange Commission has once again sounded and responded to the alarm. Insider trading defendants included 3 Netflix software engineers, 2 investors on the dark web, including a Greek national named The Bull, and the CEO of Long Island Iced Tea. They also included a global IT manager of a pharmaceutical company, an investment banking compliance analyst, a Silicon Valley trading ring, and a clinical drug trial manager and her boyfriend. As usual, these actions alleged violations of famed Rule 10b-5 and, as always, sought to collect many millions of dollars in profits and fines. While activism in this sexy field is nothing new, its warriors are growing. The commodities regulators and the cryptocurrency field, which has not even yet been designated a regulator, have begun crying foul at insider trading. Likewise, the targets are as widespread as ever. The SEC defendants in the last year ranged from California to Florida to Seattle, and in profits from $8 million down to a paltry $14,000. Truly, insider trading is being punished for activity across social classes, across business expertise, and across geographic divides. Stated bluntly, if you haven't seen this man-made wonder, stay tuned. The pyramids are coming to a town near you. And in entertainment and on TV, the spotlight on insider trading remains as strong as ever. Viewers of Shark Tank routinely watch a notorious insider trading defendant. Another high-profile defendant sells butane lighters with Snoop Dogg. In 2020, President Trump loudly pardoned the worst insider trader from the last century. And viewers of the hit show Succession recently had to listen to rapid, cryptic dialogue about Regulation FD warnings. The crime is simply everywhere, and its punishment everywhere applauded. It's as though CVS stopped printing receipts and started printing whole newspapers. Or we finally found a regulation as popular as the hit PBS series laminating small documents with Scotch tape. The point being, readers of law textbooks have to wonder how the violation's immense popularity started. What was once a novel agency approach has cemented as the law of the land. The scrutinizing eye will note that the 2021 SEC actions often centered on facts nearly 5 years old. In other words, investigations are continuously being opened and continued right up until the statute of limitations has run. Truly, what lies beneath the formidable insider trading ban is what lies ahead, namely, much more of the same. Stock Law Now says before having some fun with this prolonged morality play, let's begin by understanding the origins of the distinctly American insider trading prohibition. As this podcast segues into the history and current state of the world's most feared insider trading ban, please calm yourself while enjoying the soothing sounds of TV artist Bob Ross creating one of his pastoral settings. So that does it for that old mossy hilltop over there. Over here, let's put a big old birch tree, just swaying in the wind. Turn your brush sideways and you can easily make some branches. And maybe at the base of the birch tree, a lonely, brave rock all by itself. How it got there, we don't know. But here's a lonely old brave rock beside it. Okay, enough soothing sounds. On one level, the nation's insider trading ban is simple. Don't trade on material, non-public information obtained in violation of a duty. Material means market moving, and non-public means confidential. It's the duty part that's tricky, and we'll get to that in a bit. On another level, it's amazing that such a mighty enforcement tool lacks the authority of a statute. Sure, the Securities Exchange Act lists penalties and the applicable statute of limitations, and even codifies the ban's purpose. But the strongest ban of its type in the world was created by the SEC and the courts. And it can be invoked by a startling array of parties: the SEC, the private bar, the stock exchanges, and the Department of Justice. And oh, the yummy stories told by the civil and criminal complaints. The Wall Street Journal got compromised by professionals who left briefcases of cash for each other in health clubs. One defendant smashed his cell phone and tossed its parts in dumpsters behind separate McDonald's in New Jersey. I guess the investigators had to shop for their Happy Meal. Another stole glimpses of his wife's laptop at the breakfast table. Yet another used a code language that referenced the jersey numbers of the Philadelphia Eagles. Martha Stewart, well worth millions, went to jail for concealing a trade worth under $50,000. And of course, there was that CEO who was alleged to have met the legal standard for benefiting from stock tips by simply dating a porn star. Such a series of ethical fables stems from a surprisingly gradual evolution of a rule of law. By just looking at 4 key dates, any observer can come to appreciate why the ban is invoked so freely and so often, and to almost certain popular and monetary reward by those invoking it. The first key date in the insider trading timeline is 1934. In response to the Great Depression, FDR and his New Deal Congress set out to federalize regulation of stock sales. That's something that was traditionally handled by the states under common law notions of fraud. One is reminded of the pure egalitarian principles of the French Revolution, but not for very long. You see, although the New Dealers were fully aware of the dangers of access and privilege when discussing market-moving information, they had too much law to rewrite. With so much novel regulation being proposed, moderation was the goal of the day. Thus, the insider trading transgression was largely minimized. Specifically, when adopting the Second Federal Securities Statute, the only mention was Section 16B. Section 16B is a modest remedy mentioning a goal of, and I quote, preventing the unfair use of information, end quote. Section 16B requires only that its violators repay profits to the corporation. The insiders were delineated, the information was not. How toothless is Section 16B? Well, the SEC has never had a cause of action under the provision, which continues to exist apparently to keep boutique plaintiff firms afloat. The second key date is 1961. Legend has it that the SEC chairman was goaded by President JFK into doing something to rein in amoral behavior by corporate management. This was sort of the Wall Street paragraph to the president's New Frontier manifesto. The result was an internal SEC disciplinary action called In Re Katie Roberts, Katie Roberts being a broker-dealer. In that administrative hearing, known really only to purists, 20-year-old Rule 10b-5 was applied to brokers found to have been in a special relationship with a public company who traded upon inside information not yet made public. One broker, a corporate director present in the boardroom when news of an intended dividend was mentioned, died mid-investigation and thus avoided rebuke. His tippee was ultimately suspended for 20 days. Such business intimacy demands restraint, said the SEC, and the abstain or disclose rule was born. Note that it was this expedient special relationship between the corporation and traders that would later doom so many, including the SEC. Specifically, by focusing on the news rather than the parties, the ban was headed for overreach. However, forgetting buzzwords and admonitions, it was the choice of weapon that is more interesting to those of us who study the law. Specifically, the emergence of the elastic SEC Rule 10b-5 dictated that the crusade would forever take the battle, the gold, and the castle. Rule 10b-5, which predated the Administrative Procedure Act, was hastily drafted by SEC commissioners on a legal pad and implemented but minutes later. The rule was inspired by and still governs actions at, among other things, private companies. Thus, the onset of the insider trading prohibition ensured that it would forever apply to us all, professional and amateur alike, as well as companies both private and public in nature. The SEC subsequently enjoyed unparalleled success in strategically timed and cautiously spaced Rule 10b-5 actions. The ban grew to cover special relationship defendants both inside and outside the corporation. The blanket approach was bound to encounter judicial intervention, and thus the next chapter of the ban was penned. The third key date, for purposes of our timeline, is 1980. In that year, after roughly 2 decades of uninterrupted growth, Rule 10b-5 and the ban were stonewalled by the Supreme Court. Specifically, the Chiarella case involved an opportunistic printer on Wall Street who routinely used information gleaned from his job to trade ahead of news of mergers and acquisitions. After he was fired, the SEC sued him for the money, about $30,000 in profits. And after that, the Department of Justice convicted him. Fans of this sport will note that the printer went to prison at a time when corporate executives selling spoiled baby food received probation. Not surprisingly, enough, saith the Supreme Court. The High Bench clarified in 1980 that the name insider trader does not automatically attach to all those trading while in possession of inside information. You must obtain the inside info wrongfully. If Chiarella had been employed by any of the corporations he traded in, he would have breached a duty to their shareholders. However, being an outsider, he had no duty to anyone to abstain or disclose. The government hadn't otherwise pleaded or proven that Chiarella had acted wrongfully in obtaining his information, and so Chiarella's conviction was overturned. Subsequently, the government brought a spate of cases attempting to obtain court approval of its new misappropriation theory. That theory targets the means by which the defendant obtained the information and is thus primarily aimed at outsiders who, like Chiarella, have no duty to shareholders. The theory did well in the Second Circuit, but not so well elsewhere, until the Supreme Court heard the case of the really larcenous lawyer. And thus the fourth and final key date on our timeline is 1997. The Department of Justice, having identified a completely unsympathetic defendant, brought an insider trading case all the way up to the Supreme Court. In sum, a lawyer named O'Hagan, already convicted at the state level of embezzling roughly $1 million worth of client funds, was charged with insider trading based upon information he learned about a client from his law firm. The Eighth Circuit reversed his convictions because, like Chiarella, he was an outsider to the subject corporation, which corporation wasn't even the client of the law firm. On appeal, the justices found the facts simply too damning to ignore. Justice Ginsburg and the majority reinstated convictions against O'Hagan for a host of crimes related to his obtaining over $4 million in profits during a one-month period. At long last, the SEC's misappropriation theory had been blessed by the High Court. Namely, it was after O'Hagan illegal for anyone to trade on non-public information obtained in breach of a duty of confidentiality owed to the source of that information. Thereafter, all citizens could feel the sting of Rule 10b-5 for trading on insider information. Ironically, Justice Ginsburg's opinion confessed inevitable informational disparities among investors, but the decision nonetheless upheld a government protocol that said now Rule 10b-5 reached both insiders perpetrating fraud on their shareholders and outsiders perpetrating fraud on the source of their information. That outsider fraud could be perpetrated literally upon anyone: a friend, a patient, a family member, a client, an employer. Well, you get the picture. Finally, a third theory that had been in place for a while, called tipper-tippee, ensured that people receiving the inside information from the one who breached the duty could join in the liability, which, by the way, is almost always joint and several. And thus concludeth the lesson. Since 1997, the Commission and the DOJ have targeted cases with eye-catching profits or elitist defendants. They have punished them using a mighty arsenal stocked with disparate but complementary theories. These doctrines, enforcing a rule that never mentions insider trading, reach trading by anyone or any entity. While we stop to ponder such a potentially Leviathan reach of the American ban, please, once again enjoy another landmark from the last century: scenery painter and wild hair enthusiast Bob Ross. Yes, this tree here maybe has the last leaf of the fall. Maybe he's a lonely old tree, so we'll just paint him a long, cool stream for a companion. And then, using the tiny end of this cheap supermarket brush, we can create a two-tiered medieval castle on a warm plateau, replete with a lively moat and crenellated turrets. That's a funny word, crenellated. Here's the thing. Today's insider trading ban, as accepted in American society as jail time for tax evasion, is a cryptic blend of judicial common law and frontier justice. Many have noted its purely common law basis. What draws less attention is that the ban requires a great deal of trust of our regulators. As the Fourth Circuit so aptly stated in 1995, the ban makes us all pawns in a strategy known only to the SEC. And that strategy gets more aggressive each year. Just last month, a federal court quietly blessed the bold SEC notion known as shadow trading. Shadow trading essentially says that inside information about company number one could lead to illegal trading in the stock of company number two. This theory has simply never been posited before. Oh, there are certainly some limits to the ban. SEC Rule 14E3 seems to outlaw the spreading of inside information regarding mergers, but one would be very hard-pressed to find a case where someone was prosecuted in this country for merely spreading inside information. And the Commission does lose court cases, at least against remote tippees with a tenuous link to the source of the information. But most of the time, the Commission is successful when naming an alleged insider trader. And that defendant is grouped with his tippers, his tippies, and everyone remotely benefiting from the violation. The broad, one-size-fits-all approach could make the most pro-enforcement of scholars scratch their heads. Stock law now says we may have reached the point where too many eggs are being crushed to make this omelet. 3 truisms occasioned by a quarter century of enforcing the current common law ban invite question and debate.
One step up and 2 steps back.
Firstly, why such an outdated notion of fairness? We know that not every investor receives the same information, and even if they did, they wouldn't understand it. Fairness as a rule of law barely works on ant farms. Is it fair that athletes once investigated for sports gambling are now paid to tout sports gambling? Is it fair that a real estate broker tells a prospective buyer of a home the secret that a new highway nearby is being delayed? Is it fair that a broker-dealer gives favored customers choice IPO shares ahead of other customers, and the SEC says, okay? Is it fair that many investors do not even know of after-hours trading, and that's where the GameStop share price really ran up last January? Is it fair that McDonald's calls a burger the double quarter pounder? Why is that not a half pounder? Why? My point being, fairness may have left the building. Maybe the government should lighten up on freezing the assets of in-laws connected with the accused. Secondly, it's been 7 decades. Please tell us who exactly is the victim of insider trading. Regulators decry insider trading as victimizing markets, and followers of the American prohibition rightfully point out that our markets are the most stable in the world. But hopefully such resilience has more to do with experience and capital than the 12 insider trading actions brought by the SEC each year. Meanwhile, apart from this market victim theory, the private action known as Section 20A in the Securities Exchange Act states that the victims are those investors who bought when the insider trader sold, or vice versa. That's an entire half of the market victimized by one person. And the famed O'Hagan case, which is still the primary authority for the ban, dealt with the question of who gets defrauded in a footnote, saying the defendant defrauded either his firm's client or investors in a separate company. Go figure. And thus defendants such as Martha Stewart, Mark Cuban, and that lawyer from New Jersey continue for years to rail against the cryptic undefined crime. Some even get pardoned for it. Third truism: the scope and finer points behind the insider trading crusade are not progressing, at least not in the United States. The Supreme Court last addressed the liability for a violation in the 1980s. At that time, the notion of one insider trader being liable for all connected profits by others actually evoked laughter from the high bench during oral argument. Well, the Second Circuit has for years followed such a logical extreme, meaning that a tipper could be liable for all downstream profits, even as that total comically approaches the gross national product of a small capitalist nation. Additionally, this current trend of hypothetically targeting Congress is not new. The Stock Act of 2012, passed under President Obama, has never been applied to any congressional insider trading. This obsession with Capitol Hill access, well, it's like having Elon Musk over to your house to watch Paw Patrol. Sure, it would be great fun, but we'd still be no closer to finding a reliable Arctic canine rescue unit. Meanwhile, the most substantive changes just worsen penalties for insider traders. In a word, the sentencing guidelines, which were designed to quell the ebb and flow of prison sentences, they only flow. Changes in the last decade ensure that a convicted insider trader start at level 14 for purposes of calculating months in prison, with a maximum of 25 years. Here's a fun fact. Those same federal sentencing guidelines max out the crime of arson at 20 years. And yet we, the public, crave bigger and more. As we pause to enjoy the inescapable folly of the status quo in this area, please enjoy this happy-go-lucky solo from the relatively carefree 1990s. Okay, enough carefree 1990s. In sum, the insider trading ban, born a little over 60 years ago, is skillful, wildly unpredictable, and always garnering attention. True, that can all be said of Madonna, but she doesn't land people in prison. Seriously, in a common law nation, it's those who would make us all even who have contributed a rule of law that is truly odd. Stripped of its visceral appeal to those enjoying the spectacle of a good flogging, the insider trading ban puzzles the most experienced of analysts and lawyers and businessmen. It equates those with criminal intent with those who are just foolish. It also declares all information prior to a price rise to be material, when market news has gone from having a shelf life of 30 minutes down to a shelf life of milliseconds. The ban thrives on outdated images of millionaires taking advantage of secret merger news and then doing 6 months in a country club prison. Actually, most cases involve quarterly earnings forecasts and those who go broke fighting the SEC. The ban is further confused in the press with legal insider trading, which prompts market fortune-telling based upon timely review of lawfully filed reports by corporate management. Finally, the judges and lawyers grow frustrated with the complex legal fiction that the SEC's stances and court victories have combined to produce. And these same judges use the common law ban and its robust case law to impose truly daunting, unprecedented prison sentences and fines. All of which noise and confusion leads to this episode's soapbox, the first of the new year. Imagine a world where boutique crimes yielded to a truly generalized notion of investor fairness, where Wall Street compliance departments, defense counsel, and everyday people readily comprehend when big news can be acted upon, where criminal penalties are limited to crimes against humans and not markets, and where actual victims of fraud are the first ones compensated, where co-conspirators aren't threatened with 25 years in jail for an offense not defined by the U.S. Code, where someone can trade after a discussion at the gym without first saying 3 Hail Marys and calling a lawyer, where the most feared business regulation ever concocted applies to boardrooms and mammoth companies on the stock exchanges, but, not to the local clothing retailer that issues stock certificates to its employees. Oh, get real. These things are never going to happen. Stock law now says that when it comes to insider trading, we can lampoon the state of affairs until the bulls come home. Nothing is going to change in meaningful fashion. The info is simply too good to pass up. The SEC cases from the last 12 months spoke of profits ranging from 50% to 300%. And the punishment of the crime has launched careers for enforcement veterans and big paydays for specialized litigators. And this whirlwind of temptation and inquisition-like justice is just too much fun for the rest of us to ignore. Gazing at its perpetrators is better than watching royalty taking a dumpster dive for an expired Wendy's coupon. It's like seeing the CEO with 12 homes getting caught stealing cable TV. Schadenfreude. This is the nobility of a hunger strike paired with a Walmart Black Friday toy brawl. Like it or not, insider trading rules were aimed at the corporate insider but now frighten everybody, from waiters in bistros to the eavesdropper at the bus stop. America, look to your left and right at the casino. If you can't spot the insider trader, then it's you. I know, Cherry, I don't get them all either. But truly, the spectacle of the have quickly falling to become the have-not is the car wreck that we can't look away from, and the human frailty that Greek gods themselves couldn't resist. Accordingly, stock law now simply suggests the following. As for the SEC, the mission of equality of investor information has proven as driven as the pure snow. Yet each year brings a new round of defendants and targets, calling into question whether the actual amount of insider trading is decreasing. It's been said that it's not a good day at the commission unless somebody gets sued. Mind you, that's not what the critics say, that's what the SEC supporters say. Well, how about suing the professionals and maybe just warning the sheep of Wall Street? All these parallel actions and relief defendants and treble damages and injunctions and aiding and abetting lawsuits and disgorgements and fines and damnations form a colossal joint and several liability pool that the Supreme Court once frowned upon. Maybe the market can punish insider trading. Steve Cohen's hedge fund easily wrote a check to cover a $2 billion SEC fine. The true penalty came later on, when he was forced to run the New York Mets. Criticisms is fun. And as for punting the issue of defining the crime or its limitations to Congress, that's the leaf blower of alternatives. Namely, it's blasting your dirt onto someone else's lawn in the name of cleanup. If Congress should somehow on its own stray closer to justice and fairness in the market, that's great. But Congress banning insider trading by Congress is truly microwave heat. Nobody knows how it works, and in a few minutes you're going to have to push some buttons again. As for the perennial bills languishing in Congress about a statutory definition, placing this fairness crusade in a sole statute doesn't make it any more predictable. The European Union codified the O'Hagan case years ago, yet the disparity in insider trading actions among the EU nations serves primarily as a testament to some countries taking the offense more seriously than others. The incontrovertible observation is that the ban is a cultural thing, or worse yet, an individual market thing. Its causes and cures shall only be streamlined when all information is free, delivered at the same time, and understood by all. Until then, we all shall cherish insider trading and its disastrous consequences because it symbolizes the market inequality that even the courts have confessed exists. It's the mustard stain on the Brooks Brothers suit and the bird poop on the corporate jet. It's at once opportunity and moral indignation for all of us, baby boomer, Gen X, Gen Next, newcomer, and wizened observer alike. Stated simply, the recurring tale of temptation and reward cowers the resistance in the best of us. Whether investor, lawyer, student, or just bystander, let's join together and say, we heart you, insider trading. Hooray! Rule 10b-5 tattoos for everybody. Viva la vagaries! Viva congressional trading! Everybody, enjoy the show!
Simply irresistible. Simply irresistible. Simply irresistible. Fine, there's no telling where the money went. Simply irresistible, man. There's no other way to go.
For Stock Law Now, this is Scott Colasanti saying, as I have for some time, let's be careful in here. And as a tip for non-millennials, there's no password for Netflix. Our teenagers are signing us in with our zip code and then giggling at us, as always.
Stock Law Now is prepared, delivered, and copyrighted by Professor Scott Colasanti of Hofstra Law School. All views expressed herein are personal, so please, no wagering. For links to documents referenced herein, visit Castography at www.stocklawnow.com.